Right out of the gate, the setup tells you everything. Chaos, confusion, and a defendant already on thin ice. The narrator frames it as entertainment, but beneath that is a pattern. People who treat court like a game usually end up losing badly. When someone ignores procedure and authority repeatedly, the system doesn't bend, it tightens. This isn't a comeback story, it's a slow-motion collision with consequences that were entirely avoidable from the start.
This is State of Florida versus Stephen Allen Cooper, case number 19 CF 866. Mr. Cooper's before the court today. He represents himself. Mr. Cooper, do you still wish to represent yourself?
Yes, Your Honor.
All right. There's been a bunch of motions filed today, but print out the motion that I've denied, most of the pro se, the ones that were filed as of the 12th. Madam Clerk, dismissed, the motion to dismiss defendant's motion to reinstate bond and vacate related bond forfeiture, and notice of speedy trial.
Development resubmitted.
Yeah, and I'm gonna deny them again. All right, where we at? I dismissed the pro se notice of speedy trial demand. But okay, we'll set it for the November. Anything else, Mr. Cooper?
Yes, you dismissed them because of a certificate of service, and they were refiled with a proper certificate of service.
They were just refiled today. I have not had a chance to look at them. So I won't deny them today. I'll just reserve on that, okay? I just have not, they were not in the court file when I looked this morning. They were filed today. So I'm not prepared to order them. I will not dismiss them today, but I will have a chance to look at them, okay?
So I have a right to reinstate bond?
No, I'm not reinstating it right now. And I'm not going to reinstate your bond. You failed to appear. Judge Costello, it's my understanding that Judge Costello was covering for me, that you appeared by Zoom, and you did not come to trial as you were ordered to, so you're not getting back out of jail.
It was not willingly, though.
You're not getting out of jail, Mr. Cooper.
But I have a right to bond.
Denied. All right, well, denied.
I do have a motion that I'd like to submit to you,
can
for
submit it.
disqualification of judge.
Okay, submit it.
Who should I hand it to?
To the clerk. We'll set that for the 19th, and we'll have a chance to look at the other ones, okay?
Cooper, representing himself, is the first red flag. Courts allow it, but rarely recommend it, and moments like this show why. The judge is calm, procedural, and focused, while Cooper is already leaning into technicalities. Filing motions isn't strategy if they lack substance. It's like bringing paperwork to a chess match, busy but not effective. Now, the judge's tone signals patience but not flexibility, and that distinction matters more than Cooper seems to realize.
866, Mr. Cooper's present in the courtroom. He's representing himself. Mr. Cooper, do you wish to continue to represent yourself?
Yes, Your Honor.
And we're set for trial November 3rd. All right. Did you get the order to deny motion for disqualification of judge?
I have not received that.
All right, I'll have that printed out for you. There's some other motions that you filed. Looks like we got them yesterday. What I'm going to do is I'm going to leave this on the trial docket for that November date. I'm going to set this for October 24 for a trial management and motion day.
I got the bond reinstatement that was previously filed, and then
Yeah, I'm going to deny that motion for bond. You're based on your failure to appear. I'd already, and for the record, I have had you arrested at least once on a failure to appear, released you again on, allowed you to go back to, I believe, Ocala. On the morning of trial, after you filed a demand for speedy, you failed to appear, and Judge Costello revoked your bond at that time, had a capias, and then we had to, I think the capias was outstanding for a while. So my motion is denied.
I'm prepared to make arguments in regard to that.
But I'm not prepared to listen to them. I'm ruling on your motion. Okay?
What
And I can rule on a motion without hearing argument, and that's what I'm doing today. Anything else?
Any of the other motions?
I'm gonna hear everything on the 24th, because you just filed a bunch yesterday on the 16th, and we got them in the court file. So I'll hear everything the 24th. That will conclude today's hearing. Mr. Cooper, we'll see you then. Mr. Cooper, you're here today on your trial management. I believe you're set for trial November 3rd at 8:30. You're representing yourself. Do you wish to have an attorney appointed to represent you or talk any more about that?
No.
Okay. All right. Where are we at?
I believe it's the motions, and I have my motion to reinstate bond And
That'll be denied.
all the motions filed on the 14th that you postponed 30 days until this date, and none of them have been responded to.
Filed a traverse, responding to his multiple motions to dismiss, the motion for discharge, and the motion to quash the information.
All right.
Actually, a motion to disqualify the judge was filed as well. I believe you got that.
I think I've ruled on that, hadn't I?
I believe you got another one.
Yeah. All right, I'll get you an order of that next week. We'll leave it on the docket for November 3rd. See you then.
Are you going to give me the traverse? 'Cause I haven't received anything.
Yeah, if you don't have it, the state has this already been filed, so if you want to.
Here's where reality hits. Bond isn't a right in the way Cooper thinks. It's conditional. Fail to appear and you've burned trust with the court. The judge isn't punishing attitude, he's responding to behavior. Cooper keeps arguing fairness, but courts operate on compliance, not personal interpretation. Once you've shown you won't follow orders, the system prioritizes control over leniency. That door didn't slam shut randomly. Cooper closed it himself.
Didn't have a seat, sure. There's no contract. You and I have no contract. We resolve it in this way. It's a civil infraction, which means the city has the obligation of going first. Go ahead and have a seat and speak into the, if you're more comfortable standing. No, this isn't the time for questions. This isn't the time for questions. What we do here, this is not, we do it in a certain order. The first thing we do is, as you were cited for 2 infractions, is as I read what the officer said, until there's nothing before me, until we have the officer's statement. Once we have the officer's statement, then you can present whatever argument you want. That's the time you make your argument.
So what is it about today?
Pardon?
What are you planning on doing today?
Well, you're defending yourself against the issuance of 2 infractions.
No, I'm not the defendant.
Well,
Defendant, would you agree with me?
you're whatever you want to call yourself, a defendant, a respondent. You're the person who was issued the citations.
That's the problem. That's not the defendant.
I've read the argument. You're not raising it at the right time. Raise the argument after I've read the officer's statement into the record.
I have actually contested that statement on the return service that you received in the file.
Okay.
The statement is not accurate.
If it's not accurate, now is not the time. We don't have the statement yet. I need to read the statement. On January 2nd, 2025, at approximately 1600 hours, while on patrol within the city limits of Yelm in a marked patrol vehicle, when I observed a silver Buick traveling east on Mossman Avenue with Washington registration ACA 8168. The registration showed expired as of 11/24. I conducted a traffic stop using my emergency lights. The driver was identified as Amos Canzoni by his Washington State driver's license. Amos first gave me a random card stating he was an American citizen and did not need a driver's license. Amos attempted to argue his sovereign citizenship and that he did not need a driver's license. Amos was unable to provide me with current proof of insurance and stated he did not have any at this time. Amos was given the opportunity to contact the valid driver, but was unable to do so. I advised Amos that his vehicle would be impounded. Amos was given a criminal citation for driving while license suspended in the 3rd degree, a traffic citation for no insurance, and a copy of the TOFR. Amos was given a courtesy to his residence. The vehicle was impounded from the scene by Wharton Towing. That's what the
Cooper tries to pivot with more filings, but timing matters. Courts don't reward last-minute paperwork dumps. The judge isn't dismissing him out of spite, he's maintaining order. There's a hierarchy, procedure first, or arguments later. Cooper's mistake is thinking persistence equals leverage. In reality, it's just noise if it doesn't align with court structure. The judge's restraint here is notable, firm, but still giving process a chance to play out.
This, my American State National Credential Card, And this is all the information he needed to look up to find out that I'm not a US citizen and therefore not in his jurisdiction. And therefore, there's no issue about traffic violations because there was no crime involved. And then he refused to look up the information by his own choice. So then he required my driver's license, which I told him I can give it to him, but that does not apply because it's my license, not the DOL sign, because my name is a copyrighted name, and therefore it's in my possession. But anyway, he then went on to saying about sovereign citizen. That's an oxymoron, and I tend to say only morons use that term because a sovereign can never be a citizen. Citizen has an obligation to whatever government or state he's subscribing to, whereas a sovereign, I'm a foreign sovereign. I mean, I'm foreign to your jurisdiction. I'm here talking to you now as a lawful person. I can talk to you because we're both persons in this environment, but I'm not subject to legal rules and everything. That's up to you. That's you are subject to. I'm not. I tried to tell that to the police officer because for his own protection, I told him, look, I'm not really who you think I am. I'm a driver, not driving a commercial vehicle with interstate commerce. It's the only reason I would have the driver's license. So that's why I gave him the credential card first so he could correct his mistake. He refused to do so, and they ran me through the mill, and you know what the mill was doing afterwards. So that's all criminal now because I'm a foreign sovereign, and I posted it on my door. I posted it in my file that I have a Foreign Sovereign Immunities Act, meaning help that holds me, a man, a lawful person, immune towards the legalese, the legal subscription, which I do.
This segment shows a judge who's done this before and isn't impressed. When he refuses to hear arguments, it's not arrogance, it's efficiency. Courts don't owe endless debate on settled matters. Cooper keeps pushing, but repetition doesn't strengthen a weak position. The judge is signaling this isn't a negotiation, it's a ruling. That distinction is where many self-represented defendants lose the thread entirely.
You don't have a claim. You have to actually prove jurisdiction over me, one here. The defendant is not me, but defendant, the name, all caps name, is under my private copyright and trademark. So you basically created, not you with you, I mean the federal government created that name. And I'm asking you, do you agree that the name represents a usufruct derivative? It's something you can use to access my assets and create credit therefrom. And then without my consent or knowledge, you can then create monetary incentives for yourself and for the court and everything. But the credit and the asset still belongs to me. So the conundrum I have with you now is, you are the ones who would have to pay the fine on that violation because it doesn't concern me. It concerns a usufruct derivative, which I still don't have any control over, even though it's in my copyright and trademark. That's the whole conundrum I have with the court and with the federal government itself. You trespass upon me, you basically transform me into a defendant, all caps defendant, which I am not, and I have proven that I'm not. And yet you still try to link me to that case with that defendant, and I would claim that the government is responsible to offset all these fines or whatever you want to create under that name and hold me harmless because I have nothing to do with it. So that's in a nutshell the situation. But I would also say you have to prove jurisdiction first before you have a case. And you haven't done that so far. Nobody has rebutted my documents I filed into the court case. That means in your own rules, it's admitted truth because it has not been rebutted. It's fact and truth. And then you would technically have to honor these facts and truth. But by continuing with the charade, you do not. And you do not recognize that you're basically now in criminal contempt of the law because do I have to spell it out? As of January 1st, 2025, Poof, this court has disappeared. The municipal government has been liquefied with a Chapter 7 bankruptcy, which has been finalized January 1st. And now, basically, you don't even exist anymore. Or if you do exist, you would have to be on Washington, D.C. ground because you're not
The pattern becomes undeniable. Missed appearances, repeated chances, and still no accountability. The judge outlines history like a checklist, dismantling any claim Cooper might have to leniency. This isn't about one mistake, it's about a pattern of disregard. Courts track behavior, not excuses. By this point, Cooper isn't being judged for arguments, he's being judged for reliability, and the record isn't helping him.
put on the people of this country. Now, I have another document here. I would like to post it. I have it already filed in the docket, but it shows the residents of this country. Residents in all caps named. And we all know a resident is only a temporary living in this country or in the state. There's not a single American in the census of 330 million people. Now, my question to you is, why do you insist on treat us like sovereign citizens, which is an oxymoron, rather than recognize our status? Because in Thurston County, there's maybe 2,000 of us, if it comes to a high number. Everybody else can be treated as a dual U.S. citizens, which gives you all the rights you have, but not against me. So that's your problem now, because I have documented everything in the file. So basically, I have made a counterclaim. I nullify your claims, including the fines, including whatever you want to bring up, including the statements of the police officer. They've all been voided out by me responding, return service response. And that also would also be appearance in court, by the way. So he never not appeared in court. I just give you the courtesy. Well, it's basically not a courtesy, it's under duress. I come here to make sure I inform you of the situation you're basically maneuvering yourself into by not recognizing who I am as a foreign sovereign, because I'm outside of your jurisdiction, period. So that's why you don't really have a case. And it would be wise if you would allow the prosecutor to file a notice of dismissal or cancellation of the case, because it won't have any jurisdiction.
Short hearings, same outcome. Denial after denial. Cooper keeps filing, but nothing changes the core issue. Trust is gone. The judge isn't reacting emotionally, he's applying consistency. That's what makes this powerful. No theatrics, just steady enforcement. Cooper seems to believe persistence will wear the system down, but courts are built to outlast that strategy every time.
That from your
Okay, so I give it to you here. This is what's not in the docket. And then also, in order for me to be protected, we also have a private indemnity bond. In case I would be involved in a crime or in some property damage, that indemnifies me. I don't need a bond like you guys do. I just need an indemnity bond. So that means if something happens that causes a lot of financial problems, that indemnity bond would be able to connect all of it. So that's the document. And you can see there's two barcodes on there, or whatever they call it. You can access my documents like the police officer could have easily gone, scan those two barcodes and get into the file, and then all the files are in there accessible, the same ones I put into the court case now. So basically, there was no reason for the officer to do anything else except, oh, excuse me, I made a mistake, have a good day. That would be his proper response to me as identifying me as a foreign sovereign. And he did not do that, and the court did not do that, and I don't go into details right now, but it has been a lot of hassle against me, who is not even involved in this one. That's the problem I have with you now, that you don't.
Now we shift to a new case, and immediately the tone changes. This isn't just confusion, it's ideology. The defendant walks in with a belief system that rejects the court itself. That's a dangerous starting point, because if you deny the rules, you can't play the game. The judge senses it instantly and prepares to manage not just a case, but a worldview, clash.
You're entitled to use any name you want as long as you're not doing that to defraud anybody. Now, it's not of any interest to me whether you call yourself first name, last name, first name, comma, uppercase, lowercase. It's the person that's sitting in front of me. They take it, it's my turn.
Okay.
But you're arguing that you're basically exempt from, you're exempt from the rules that would apply to the citizens of this country. The problem is you may be, may not be, call yourself a citizen of this country, but when you're using the roadway, you're subject to the rules of the roadway, no matter what you call yourself, a foreign citizen, a sovereign, it doesn't matter. Is this person using the roadway? When you do that, there are certain requirements that apply to the people using the roadway. And if you were, then the officer says you're within the city of Yelm on a road on Mossman Avenue, take judicial notice of that. That's a certified road. You are subject to those obligations. Now, I'm very familiar with all these arguments. I suggest you, it's my turn, sir. I suggest you read State v. Williams. It's in 143 Washington 2nd, which goes into this. We're talking alternative realities here. The reality I subscribe to, this is the state of Washington. This is a validly established court. I have jurisdictions over minor matters, infractions committed within the city by the people that are driving on the road, for example. Now, you don't believe that? State versus Williams goes into that in some detail. They call these arguments, I've looked through this as, at one point they refer to them as semi-literate gibberish, which is basically what it is. These are specious arguments that I don't have to, I'm not taking into effect. They are not recognized in any court in the United States. I know there's a wealth of information, hundreds, thousands of these articles on the internet. You can pull them off. For example, this one signed by Anna Marie Reisinger of Alaska relating to the United States Corporation and the USA Corporation. It's all very interesting, but it has no meaning.
The judge lays out procedure clearly, almost like a teacher resetting a classroom. But the defendant resists structure from the first moment. Interruptions, objections, and philosophical detours, all before the case even begins. This is where many of these encounters unravel. Timing matters. Even valid arguments fail if delivered at the wrong moment. The judge isn't shutting him down, he's trying to keep order.
By a Washington driver's license. He did cite you for license suspended, but I'm not able to find that you didn't have a valid license, and so I'm going to dismiss that. However, I've not been furnished with proof that you had insurance, so I'm going to find that you committed that infraction.
Remember, I said to you, I have an indemnity bond. If anything happens to me in a traffic accident or something that causes damage to somebody else, I'm indemnified. And the word indemnified
by who?
Can tell you that it's nothing to do with you. It's to do with the people of this country.
No, the law in the state of Washington is that you have a valid certificate of insurance from a recognized issue of insurance. A piece of paper that says I'm indemnified doesn't mean anything to me.
Yeah, but you see, you don't get the point. The point is, you are working for a governmental subcontractor, which is now liquefied. But the point is, you have contract with the country, with the people of this country, and which is the Constitution of 1789 and 1790, which gives you enumerated services, powers, and traffic control is not one of them. So you usurped all these powers, and I think your legalese people here are Barcodes and banks. These are the republics that read this whole thing. Now, you can claim ignorance of the law. You can do that. But I gave you the information, and according to your own UCC, once knowledge is given, what is a license if you are a...
The insistence on redefining roles, I'm not a defendant, is classic deflection. Labels don't change legal reality. While the judge handles it cleanly, call yourself what you want, but you're still the person cited. That's the key difference between identity and responsibility. The defendant is trying to win by redefining terms, but the court operates on established definitions, not personal belief.